You may have received a notice that your case is ordered to court mediation or to the Family Court Services mediation. In California, in most cases, the courts require a court mediation before they will hear disputes concerning child custody. Child custody mediation gives parents a chance to resolve disagreements about a parenting plan for their children. In mediation, the parents have the help of a court mediator in resolving their disagreements. If the parents are able to work out an agreement, the mediator helps the parents write up a parenting plan agreement that may become a custody and visitation order if it's signed by the judge. The goals of the mediation are to, one, help you make a parenting plan that's in the best interests of your children. Two, to help you make a parenting plan that lets your children spend time with both parents. And number three, help you learn ways you can co-parent. The specific procedures for court-connected mediation vary from county to county in California, including the length of the mediation. One of the biggest differences between the counties is the extent of the confidentiality in the court-connected mediation. In many counties, like Orange County and Los Angeles County, the mediation is confidential. The mediators may tell the court only whether or not the parties reached a full or partial agreement, and the parents must consent to the writing before the mediators are allowed to even give the court a description of the issues that are still in dispute. These confidential mediators may recommend some emergency procedures, such as requesting that the judge appoint a lawyer to represent a child or to recommend an investigation for certain serious problems. However, as a general rule, they only report to the court whether or not there was an agreement. In some California counties, the courts have adopted a recommending mediation approach. In those counties, the court mediators may submit reports and recommendations to the court if the parties don't reach an agreement. Here are some general rules that apply to all court-connected mediations, whether or not they're confidential or a reporting county. First, if a mediator suspects child abuse, neglect, or has concerns about the physical safety of any of the children, that mediator may have a mandatory duty to report such incidents to Child Protective Services or the court. Secondly, the purpose of the mediation is to help the parents reduce conflict and to develop custody and visitation agreements that serve the children's best interests by ensuring close and continuing contact with both parents. Number three, in both reporting and confidential counties, mediators must meet certain qualifications, including graduate degrees and experience in counseling, psychotherapy, or related fields. They also have specialized training in child custody and visitation mediation, as well as domestic violence, and they have knowledge of the California court system and the family law procedures. So what happens at this court-ordered mediation? The mediator will meet with the parents together, or if there's domestic violence, sometimes they meet with them separately. Make sure you are on time for the mediation appointment. If you're late, the mediator may cancel the appointment and report you as a no-show to the court. Remember, you were court-ordered to attend the mediation, and failing to appear is considered a breach of the court order. If you cannot attend the mediation, please contact your attorney and the Family Court Services Office immediately. The phone number for the Family Court Services Office is usually included on the notice for the mediation. In confidential counties such as Orange County or Los Angeles County, the minor children typically do not usually go to the mediation. In recommending counties, the children may be requested to go to see the mediator for an interview. During the mediation, the mediator will ask questions to develop an understanding of your family history. Remember, in cases of domestic violence, you do have the right to meet with the mediator separately, and you can bring a support person to your mediation. The mediator and the parents will identify the most important issues that need to be resolved. And the mediator helps the parents to focus on developing a parenting plan that is in the best interests of their children. The mediator will share information on the needs of the children for different ages and different stages of life with the parties who are at the mediation. The mediation may address legal custody, parenting plans, holiday and vacation schedules, transportation issues, and other areas that relate to the needs of the children. However, typically in the court mediation, you will not be discussing child support. You and the other parent will consider your options, and you have the opportunity in the mediation to resolve all, some, or none of the issues that are before the court. If you want more time with a mediator, we can suggest a private mediator who can spend more time with you and try and reach a resolution with the other side. Working with a private mediator will cost money, but it can be a valuable way to resolve the differences and work out a parenting plan that will support the children and work well for your family situation. So if the court-ordered mediation was going well, but you didn't quite get a resolution, you might want to consider private mediation. A lot of times I'm asked whether or not the attorney will attend the mediation with the client. For the court-ordered mediations, that varies from county to county. Typically in the confidential counties, such as Los Angeles or Orange County, the attorneys do not participate. However, sometimes they do request the attorneys show up later if they believe that there's an issue the attorneys can help with. It could be very helpful to you to get legal advice before the mediation. So make sure that you have the time to speak to your lawyer so you can understand your legal rights and responsibilities and develop options for reaching an agreement when you go to your court-appointed mediation. It's also a good idea to schedule a brief call with your lawyer a few days before your court mediation to discuss the issues and potential agreements that you could reach during the mediation. If you cannot reach an agreement at the court-ordered mediation, then your court will proceed to the hearing. There is usually a court hearing or settlement conference that the judge will proceed with right away unless the parties agree to private mediation or a settlement. The judge can make decisions on a parenting plan. The judge may also order something like a child custody evaluation by a mental health professional to get more information before making decisions about the child custody issues. This video gave you an overview of the court mediation process. If you have other questions concerning mediation or any issue in your case, please contact our office. I hope the mediation goes well. Remember, the more issues that can be resolved, the less litigation you will need to face in the courtroom.